Divorce can be a long and difficult process. In Michigan, there are many steps to take before your divorce can be finalized. Michigan courts cannot finalize a divorce until at least 60 days after the complaint is filed. If minor children are involved, then the wait is extended to 6 months. Michigan is a true no-fault state, meaning you do not have to prove wrongdoing by your spouse. You also do not have to go through a legal separation period before filing. Step 1 is to serve your partner the divorce papers. This must be done formally and cannot be served yourself. Your partner, however, can either respond informally via mail or email, or formally with a process server. They also have the option to accept service and waive formal service of process. The petition must contain certain information about divorce, including both your and your spouse's names and contact information, the grounds for divorce, division of property if children are involved, and if so, their identifying information such as ages and locations, child custody expectations, and whether you are requesting alimony or child support. If your spouse does not answer the petition within the required time frame, the court will likely grant you a default divorce, aka uncontested divorce. However, the spouse usually responds either by agreeing to the terms or filing a counter petition introducing new information for the court to consider. During the divorce process, a temporary order is used to provide immediate rules. These rules pertain to children and financial matters that cannot wait for the proceedings to finish. It can be facilitated by a court or by mutual consent of both parties. Next, the discovery phase will have both parties share all information related to the case. Throughout this phase, attorneys will investigate facts that could be disputed during trial. Attorneys can use interrogatories, depositions, and request document production. They can also consult experts such as appraisers, accountants, or psychologists for child custody matters. After all information is gathered, the negotiation process begins. Both attorneys organize an informal settlement discussion with both parties attempting to settle the matter outside the courtroom. If successful and an agreement is created, a mutually agreed upon settlement document will then need to be drafted and signed. Another option is mediation, with the goal to create a settlement. With mediation, the court won't have to intervene and both parties can save time and resources. You can always choose to mediate during the divorce, even before filing. All you need is a mediator, which is a neutral third party. If neither of these options are viable, the court will require a formal settlement conference in which the court further attempts to find an amiable solution for both parties, focusing specifically on property and support matters. Both parties, their attorneys, and a judge must be present at the conference. If an agreement is reached, it's possible for the terms to go on record. However, if a full agreement cannot be reached, then the judge will select a date for a trial. If you have any questions or are considering filing for divorce, please contact Fausone and Grysko, PLC, online or by phone at 248-380-0000.